come to order. District Court is now in session. I will stand as Perkins presiding.
We will hear the matter of Laura Karst and Kevin Shores, FA 11992. If the parties are present, they can come forward to the table. I know Ms. Karst is here. I also note for the record that Mr. Shores is here. So Mr. Shores, if you wish to take part in this proceeding, you're going to need to come up to the table so that you can be near the microphone.
Excuse me 1 second, ma'am.
Yes.
Before I proceed, ma'am, can you tell me if this is a court of record?
It is. I am the district court judge.
And that the court make known that I am not waiving any rights granted to me, inalienable Constitution of the United States, Constitution of Minnesota, and all treaty rights, as I am an enrollee of the White Earth Reservation.
And I will note, Mr. Shores, that you have brought a number of motions objecting to a number of things, and that all of those are going to be addressed today.
And can you tell me what is the labeling of these proceedings?
This is a motion hearing to address all the filings by both you and Ms. Karst.
And
All right, so Mr. Shores, if you want to address any further, you're going to need to come forward so that we can actually have this recorded on the microphone, so that we can have a proper recording of the proceedings.
I'm still trying to find my device here, ma'am. I'm sorry. I did put in a motion at this time.
Yes, and Mr. Shores, if you want to address any of your motions, you're going to need to come to the table.
But
I note for the record that Mr. Shores is still seated in his wheelchair away from council table, so that
where
I
am
don't know how much of this is being recorded. So,
ma'am, I can project my voice, and I know I am in the galley. And before I come aboard, I want to make sure that we are going to be following the laws of the Minnesota Constitution, correct?
correct?
And the United States Constitution,
Correct?
and the Americans with Disabilities Act,
Correct?
and also treaty laws.
Correct.
And in what capacity are you presiding over this?
I am a district court judge in Clay County, Minnesota.
A non-elective?
I'm sitting as an elected official.
You've gone through an election?
No, I was appointed to an elected position.
Right, so non-elected position.
It is an elected position.
Appointed position.
Mr. Shores, I am not going to argue any further. I'm going to indicate that if you want any of your motions heard, you need to come to council table so that we can address them properly. If you don't want to do that, you don't have to, but then I'm not going to be taking any further comments from you until you are being properly represented.
Objection. I put in a motion of a trial by jury of peers that is afforded to me by all constitutions, and by you not granting that, you are Judas non, sorry, I'm still trying to find my terms. I apologize, I am not good with Latin.
Mr. Shores, that's one of the motions that we're going to address today, but in order to do so, you need to sit at council table. I'm going to ask you one more time, if you would like to participate in these proceedings, you need to come to council table.
Okay, so under duress and not understanding why I need to be at council table, I shall unwillingly participate, but I am still proclaiming my writ of subrogation and also the trespass in violation of my rights by you forfeiting your position as a judge.
All right, so you're gonna sit at council table, thank you. I will just note for the record that Mr. Shores is now going up to council table in front of the microphone.
And can you answer why you need to declare that?
Because my court reporter is an electronic court reporter, and so everything is recorded electronically in order to do so, and we need to have it.
Microphone's right in front of you.
Alright, so
You're a
we
little
are
bit
here
angled.
today. There are a number of motions that have been filed by both parties that we need to address. And I'm just going to go through and outline what my understanding is of all of the motions, and then I'm going to let the parties make any further arguments that they need to, knowing that I have reviewed everything that's been filed in this matter. So, initially,
Objection.
Mr. Shores, I'm speaking now, and I'm just going to lay out how we're going to proceed. I'm going to lay out the procedure in this matter. I'm then going to ask both of you to state your positions as it relates to the motions that have been
Objection, Coronel Judas.
All right, so I will just indicate, first of all, that Ms. Karst had initially filed a motion for contempt as well as a motion for parenting time assistance. Ms. Karst, those were your only two motions initially that you filed back, I believe it was in September or October, correct?
It was in January.
Well, the new motions.
Yeah, it was just those two, yes.
All right. And so then Mr. Shores, excuse me, I do note that after those filings, and prior to that, you had filed a number of motions related to those as well. And you filed a number of motions on October 1st, 2018, or at least that the court put into the file.
Objection.
On October
Mrs.
1st.
Karst did not serve me papers.
I had served Mr. Shores.
All right, so you were served with a number of filings back in September and October of 2018. Those are the motions that I'm talking about. And so on October 1st, 2018, Mr. Shores, you filed 11 motions regarding failure to state a claim, a writ of quo warranto, writ of discovery, motion to vacate, avoid judgment, motion for relief of judgment, motion to vacate a support order, a motion to many the trial by jury, objecting to a non-judicial person hearing the matter, being deprived and restrained of your rights, making an objection by special appearance, and then multiple other motions on October 1st, 2018. Then I do note that on October 16th, the court received a petition for counterclaim from Mr. Shores. On October 28th, there was a motion to impose sanctions. And then on November 16th, there were a number of motions again addressing some of the same issues. And on November 21st, there were a number of motions that were also filed by Mr. Shores. I also note Ms. Karst responded to a number of those motions and brought the motion to basically impose sanction as well.
Yes.
All right. Mr. Shores, I know that a lot of your motions relate to the original decree that was issued by Judge Cahill. Is that correct?
That is a void order. Any orders made by Cahill are a violation and trespass against my rights. Therefore, they are all void.
All right, and that's your position as it relates to that original decree that was issued in 2012. Is that correct?
That's according to the law, ma'am.
And I understand that that's your position, correct? All right.
The burden of proof is on Mrs. Karst.
All right, and so as it relates to the original judgment and decree, and
Which I have not received.
it's from 2012, and I would note that That order was appealed by you, Mr. Shores, correct?
It was attempted to, but I had a lawyer that took me for, yeah.
All right, and back in 2014.
But objection,
Mr. Shores, I'm speaking now. I will let you have an opportunity to speak when I'm done speaking.
clarification, ma'am,
Sure.
of what you were just going back about with Judge Cahill.
Yes.
I was never properly given due process of law. So can you clarify how any of those orders stand?
Well, and I'm just trying to get through your process, and I understand that you have made a number of motions attacking that original order. One of which is because you're claiming that there was no due process. You're claiming that that order is void and invalid, correct?
Absolutely.
All right. I'm noting that there was a trial in that matter, and that after that, you, through your attorney, appealed that order, and the Minnesota Court of Appeals affirmed Judge Cahill's order, and that opinion of the Minnesota
Objection.
Let me finish Mr. Shores first. That order was issued on May 5th, 2014. What is your objection?
So can you, I demand that you prove that that's a valid court order.
All right, and I'm going to end up issuing an order regarding all of your motions. And so my question for you is, with regard to the issue that you have before the court, that this is a void order, that you are deprived of due process. You've done all of your filings, and I've read all of those filings. Do you have any other information that you want to provide to the court to support your argument?
Well, I think we need to go because I'm still not getting a trial by jury, and that supersedes all laws. And I apologize, I'm still trying to find for the proclamation of it, but by you not giving me my rights to the Constitution and this being a jury trial, then you are trespassing upon my rights of life, liberty, and the pursuit of property.
And we're going to get to your request for a jury trial, Mr. Shores, but if the initial order was not void, then my question is, what are you looking for a jury trial on?
Right now, Mrs. Kars is trying to deprive me of my rights.
And that gets into, are you talking about the contempt motion that she's brought?
All rights. My rights of life, liberty, and the pursuit of property. Just the threat of bringing me to court, the threat of throwing me in jail, the stress of this is depriving me of my rights. So this should be a trial by my peers.
All right. So I understand your argument as it relates to the jury trial issue. And again, the court will be ruling on that as well as all of the other motions before the court. Do you have any other information that you want to share with the court as it relates to any of your other motions besides what you have already filed with the court?
It will depend upon the ending of the proceedings.
All right, because I will tell the court, or I'll tell the parties how I'm going to proceed. It appears, as I indicated, Mr. Shores, you are attacking the initial judgment by Judge Cahill from 2012. You've made a request for a jury trial. You've made a number of motions regarding whether or not you're entitled to discovery or information on this, on the contempt, the new motions.
And the child support.
And the child support. And I note that all of those issues the court needs to make rulings on those issues before we can get to the actual contempt issues. And so my plan was to hear from both of the parties, and Ms. Carsey will also allow you to have an opportunity to respond to Mr. Shore's motions in any additional information that you haven't already supplied. If, depending on the rulings from the court as it regards all of the issues that Mr. Shores has raised, if there are any issues left to decide, then we will set that matter on for a further hearing as it regards the actual contempt issues. And so, Mr. Shores, do you have any other information that you wish to provide to the court, or any other arguments you wish to provide to the court?
Oh, also, I would like to make a motion at this time that if this gentleman is to assist me, that he be paid at the rate of $15 an hour by Mrs. Karst due to hardship.
All right, you're gonna have to file a written motion, and I do not know under what authority I would have to grant any such motion, but
Because of the financial burden it will have to take for me to reciprocate the assistance. Because unless the court is going to provide me the assistance with the ADA.
well, and Mr. Shores, first of all, I do not know that you filed any request to proceed in form pauperis in this action. And so I don't have any information that would provide me with the right to.
I have no income, ma'am.
All right. Well, at this time, I don't have anything before me that shows me that I have the ability to grant that motion, and so I'm not going to be granting that at this time. I do know that at this time, Ms. Karst is proceeding in form pauperis, and it's been determined by the court that she doesn't have financial resources to pay for things like filing and service. And so with that order in place, I don't believe that I can make any finding that she has the ability to pay anything else. So now, Ms. Karst, do you have any responses besides what you've already filed, because I've reviewed your responses already, to the motions that Mr. Shores has filed with regard to the procedural issues, that there is a void order, that there is a right to a jury trial, all of those issues?
Excuse me, everything I believe has been addressed. His issues of, I guess everything I've asked for to be dismissed because everything he said is not warranted by existing law, and I have refuted every single one of his claims in my motions for dismissals. So I don't think I have anything more to say on the record.
All right. Then there was one other issue that I did want to address with the parties with regard to Ms. Karst, your motions, if we get to them. One of the contempt motions is because of some non-payment of a property division, correct? All right. And I know that the court will still need to rule on whether or not that's a void judgment or whether or not that's an invalid order. But if we move on to the next step, which is potentially the contempt action, under my understanding of Minnesota law, there are two different ways that you can do contempt. Child support, which is allowable for contempt proceedings, but that property divisions are not allowable for contempt proceedings. Those are regular judgments that you can basically enforce through other judgment remedies. So do you have any other case law or any other argument that you can give to me that shows that that is a proper forum for a contempt action?
As far as for the property division?
For the property division.
No, I don't.
Okay. All right, so Mr. Shores, just to let you know, as it relates to the motion that Ms. Karst has filed regarding the property division, not the contempt or the child support, but the property division, irrespective of how I rule on your motions on whether or not the order is void, I can't go forward on contempt with regard to that, and that will be a ruling that I'll make in my final order. It doesn't necessarily address the child support if we go forward on that, but it does on the property.
Objection. You cannot make such a ruling whatsoever which would deprive me of property without a trial by jury.
All right, and as I indicated, Mr. Shores, I will be addressing that issue in my final order. What I'm also indicating is that Ms. Karst doesn't have a remedy to go forward on contempt with regard to that issue. So I'm denying her motion on that issue. So she's not going to get to go forward on that issue. But there are other issues that may have to be determined at a later hearing. All right. Mr. Shores, is there anything else besides what you have indicated in your filings for the court to know as it relates to this matter?
Yes, I have 4 things right here
All right.
for filing.
And what are they?
I don't know what is going on with. Is there Wi-Fi in this room? Do you know?
I believe so.
Okay, because I think it tried to sign me into something and it's interfering with my document reader. So every time it tried, well, it's not doing it anymore, but now I lost my placement, and so I have a huge list I got to go through. But, well, as I declared, I can't find the paperwork, but since I am using the assistance of, why, could I just submit this and have the court reporter?
Well, I need to know, I would,
There are 4 more motions, and the first one that we should address is for you to recuse yourself from this position for trespassing on my rights.
all right, and I do note in one of your prior filings, you also did a motion for recusal. The time for a motion to remove me has passed because I was assigned to this matter a number of months ago. I've already had a hearing as it relates to these matters.
Objection. The minute that you violate the law and your oath, which I did request the first, oh, sorry about that. Forgive me, ma'am. But you validate your oath and you recuse yourself by not granting me a trial by jury.
And as I indicated, Mr. Shores, I will be addressing that issue in a written order.
Can you clarify why that's not addressed right now?
Because based on my understanding of the law, I do not believe that you have a right to a jury trial in this family court proceeding.
Ma'am, anytime I'm to be deprived of rights, I am afforded by jury trial. If you look, and this is where I'm trying to find the document, if you look at what I filed with the court, it gives there many cases that are cited, and it gives you the actual law of the Minnesota Constitution. I believe it is 7. Well, I'm trying to go off memory, but I got it written down because you have to learn a lot of stuff to be here. But you're violating the Constitution, ma'am.
And I understand that that is your position.
It's not a position. Can you clarify? Can we read the article then as soon as I find it? I mean, we can go to Google Scholar and type in Minnesota Constitution, writ of habeas corpus.
Correct?
And it comes up and it says anytime that an individual is going to be deprived of $20 or more, he has the holy writ of habeas corpus.
And Ms. Karst, I understand that you want to respond, but Mr. Shores, I understand what your position is. However, I also understand that there is a law and case law in the Minnesota Supreme Court that indicates that in civil actions, in family law actions, and in contempt actions, that there is no right to a jury trial.
That's incorrect, ma'am.
And you can disagree with me, Mr. Shores, but my written order will outline the case law that cites for support of my decision. Now, is there anything else that you want the court to continue? You talked about a motion to remove, but the timing for that is past. So you also indicated that there was 3 other motions. What are those motions?
Jury non-prudence. That you forfeit your position as a judge, and well, like I said, I'm still trying to find the document and pay attention. So if I may just get 1 minute to find the document.
I will give you 1 minute, but I also cut off Ms. Karst and I didn't let her proceed.
Oh,
So Ms.
I'm
Karst,
sorry.
Yep, and so Ms. Karst, I'm going to let you answer. I'm sorry I cut you off.
That's okay, I was just going to say, I believe that all of this is beside the point of why we're here. None of these issues are why we're here. And I'm worried that we are never going to get to the reasons why we're actually here. And I did originally file this paperwork almost a year ago. So I know he has lots of issues to discuss, but I'm hopeful that we can get to the actual issues.
And I understand your position, and I know that this matter has been going on for a long time, part of which had to deal with the fact that there was a judge that retired and a new judge that came on. And then that there were a couple of continuances just because of the large number of motions that were filed on both parties' parts. And so I wanted to make sure that both parties had an opportunity to respond adequately to both of them. And I know that you did that as well to respond to Mr. Shore's motions. It is the court's intention to take the issues, the procedural issues that Mr. Shores has raised, take them under advisement so that I can issue a formal written order as it regards all of those. If his motions are denied, then I've already indicated that one of your motions can't go forward. But as it relates to the other two motions, the sum and substance of them, then we will have a hearing just related to those. All right?
Yes, please.
All right, so Mr. Shores.
I had to restart it. I'm going to try my other device. I don't know why this one isn't.
Actions available.
Well, can I just have these handed to you, or can the bailiff hand these to you and we can just go from there?
The reason that I'm asking, Mr. Shores, is that under the rules of procedure, all motions needed to be filed at least 5 days before the hearing in family law matters. Today is the day for the hearing. There have already been...
So, ma'am, I thought you already said that this is a court of records.
It is a court of record. There are 34 motions that you have already filed in this matter. And so I need to know what these additional motions are to determine whether or not the court will even receive them at this time.
Well, that's why if you take a look at them,
I will take a look at them, but I'm not necessarily receiving them.
so you're refusing my motions.
No, I want to look at them so I know what they are, since you can't, so I can address and put on the record what they are. So
Well, then we can just have the bailiff read them out loud.
The bailiff is right there. If you want to hand it to the bailiff, and then I can read them into the
Hold the
record.
file?
You see this file here with the clip, sir?
Yes, sir.
Okay.
May I take the whole file?
I would rather you just leave it right there if you're just going to read it from
I'm
right
not
there.
going to be reading it. You give it to
The
the
court's
judge.
going to read it into the record. So, Mr. Shores, I'll give them back to you as soon as I've read them into the record. All right. So I have a notice to the court invoking rights against Bill of Attainder laws secured by the United States Constitution, Article 1, Section 9, Clause 3, and invoking equal protection of rights under the 14th Amendment, invoking the Supremacy Clause under Article 6, Section 2. So, Mr. Shores, my first question to you is this different from any of the other motions that you have already filed in this matter?
No, that should be a second respond to one of the other motions.
Then there is, I believe, the motion to recuse, which I also note has previously been filed in this matter. Then there was a notice to the court objection demanding clarification of evidence of jurisdiction to justify suspension of writ of habeas corpus. I believe that that was also filed in your filings from October 21st.
That one I do not, I think you may be mistaken on that one, ma'am.
That's what I'm looking.
I think that one is a response to the fact that you have still not made any answer to those, which is a question I do have for you, ma'am.
You have filed a motion objecting and demanding clarification of evidence of jurisdiction to justify suspension of writ of habeas corpus. That was filed on November 21st, which I believe is the same motion that you have in here. Then,
What date again did you say, ma'am?
November 21st. Just in your most recent filings.
Okay, I do believe that there is a slight variance between those, ma'am.
All right, and what's the difference?
I'm having challenges getting into my device here, and so I would say, well, I'm trying.
Yep.
And so right now I'm sitting on the whole Americans with Disabilities Act and trying to find this document. I had everything in a document of list, and I'm trying my other device now. Which one is the one that the date of the one that I just gave you, ma'am?
Well, I don't know if it's the exact same one. The one that I just read, you have it dated November 29th, but I have a similar motion that was filed with the court on November 21st.
That's the objection, trespass
No,
of
this
judge?
is objection demanding clarification.
Clarification,
of evidence
okay,
of jurisdiction.
one sec. I hope the court understands that because of my site limitations, I have to scroll through all of these lists of documents, and somehow they're not in alphabetical order anymore.
And that's why I'm giving you time, Mr. Shores.
Well, I appreciate it. I apologize, I'm not finding that one. So I would like to submit it, but if it is a duplicate, then I would gladly pull it and apologize.
I am pulling up a document in the court's file that is, it's got the exact same heading. It's the notice to court objection demanding clarification of evidence of jurisdiction to justify suspension of writ of habeas corpus. So that was one of the filings that the court pulled up from the court file that was filed on November 21st. And so that does appear to be a duplicate.
Okay, and that's one that you still have not to this date addressed, correct?
That's one that I will be addressing in my written order,
Can you explain to me why you have not addressed that sooner?
because it was just filed on the 21st for hearing today.
That wasn't the habeas corpus, wasn't that filed immediately? The
Anything
request of
related to-
habeas corpus?
Anything related to the writ of habeas corpus was all filed on November 21st.
I would beg to differ on that, ma'am.
Well, and
That came in the second wave of motions.
oh, well, there was a writ of Toronto filed on November 16th.
That came out right away
Yeah.
too, but the habeas corpus, that's new.
Yes, that was on November 21st. All right, that's what my record is also showing. And that was the purpose for today's hearing, was to address all of the motions that were filed, to allow both of the parties to make any further argument on any of the motions that have been filed in this matter. And so,
Well, according to the Panoia ruling, habeas corpus is the way to clarify all challenges.
and I understand that that's your position, Mr. Shores, and as I indicated, I will be issuing a decision on your request as well as all your other requests. So, the last thing that you have here is a notice to court objection trespass upon rights. I want to clarify what that motion is.
I'm sorry, can you repeat that, please?
Yes, notice to court objection trespass upon rights, 18 U.S.C. section 242, deprivation of rights.
Can you read a little bit more on that so I can get familiar? That one I think is a brand new one.
That's correct, and that's what I need to know, why I should be accepting that today.
Well, because I can't pull it up right now, and off the top of my head, and the frustration of going through this, and the stress and the trespass of my rights is giving me some challenges.
And so, well, first of all, Mr. Shores, I'm assuming that Ms. Karst has not been served with any of these either.
I've been served with copies of any of your things.
That's not correct, ma'am. It is, as it has been established by the higher judge in Detroit Lakes, that all things can be emailed. And also, as a courteous, we've mailed them too.
All right, so, I know, Ms. Karst, you received some of the documents because you responded to some of them.
Yes, I received the first 13, those are the ones I asked for dismissals.
Yes.
The next 6 that came in, that came in about 2 weeks ago after Mr. Short asked for the extension because he was having computer problems. And then all the motions came in, and these new 4, if these are in addition to these 6 that came in, then I'm not seeing those at all.
All right, and so there were some motions that were filed and some objections that were filed on November 16th. 1, 2, 3, 4, 5, 6, 7 of those. And then there were on the 21st, 14 motions. Did you receive the motions that were filed on the 21st?
No, on the 21st, I thought there were only these 2 new ones that had come via email. So
Objection.
I'm confused, but,
Objection.
Mr. Shores, I'll let you speak in just a moment.
I could read to you the new ones that I got.
Sure.
Okay, it's notice to the court, memorandum of laws, judicial cognizance, good faith and credit clause. I responded to that. Notice to the court, objection, demanding proof of a valid judgment by peers, proof of contempt. Notice of trespass, demand for dismissal of judgment issued by a person, not a judge, or a non-judice, for violating the respondent's secured rights for equal protection and due process of the law under the 14th Amendment. All judgments made in violation of the 14th Amendment are void. A, B, intuio under SCOTUS Burnham versus Superior Court. The next one, notice of petition demand to court to set aside void judgment, CF Federal Rule 60, lack of jurisdiction. The objection, state of support order until determination by a judicial officer of court. Notice of petition for counterclaim, demand dismissal of Federal Rule 12b6, failure to suit a claim, default, failure to respond. And I didn't respond to the notice demand of writ of full warning tool because I don't think that one's exactly for me. But.
All right. So it looks like you received everything that the court at least received on November 16th.
Okay.
So, Mr. Shores, you did file a number of things that the court at least received on November 21st. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. There were 14 motions filed with regard to, on that date.
Right, but ma'am, it was clarified by the higher judge that these motions can be provided by email, and Mrs. Karst gave us an email for such things to occur.
All right, and so that's my question. Did you in fact email all of those motions from November 21st to Ms. Karst?
They probably were emailed a few days prior.
Okay.
I see what he's, okay, I see what he's talking about now, because I was mailed copies of those already, and I did get attachments of all of them.
All right.
Those are the ones I had responded to prior.
All right. All right, I just wanted to make sure, because there was also an affidavit of mailing in the file, because you also, Mr. Shores, it looks like you also mailed those in addition to emailing them, correct?
Yes, ma'am.
All right, so that's taken care of. So we don't have to deal with that. But these, and it appears from my review of the motions that Mr. Shores has here, that all of those are similar or identical to the motions that were filed on November 21st.
Ms. Your Honor, I believe all of these boil down to evidence of an injury in fact, judgment of a trial by jury of peers, a non-judge presiding, which it wasn't, but, and then the order being void, as he claims. And these are all objections that I addressed in all of my other dismissals, so I was going to just ask that these all be dismissed with prejudice also, because they're already things that addressed.
And it does appear that a number of these are motions that were repeated. And so the court's position on this matter is that all of the motions will be addressed in the order. If there are things that were filed more than once, I'll address the fact that they were filed on separate dates, and I'll address my rulings as it relates to each of the motions. But because these filings, Mr. Shores, are being filed today, as well as the fact that they appear to be filings that were already provided to the court, I'm not going to accept these 4 motions at this time. And at least those 4, even though they may be duplicative, have not been served on Ms. Karst, so I'm not going to accept those at this time. All right, so, Mr. Shores, anything further for the court at this time?
So then we're setting up, well, I just want to make it known to the court, because of that lack of granting, I asked the court to grant me a 5-week extension on that, because I am on a strict schedule. I have people that come into my home that help me with my daily living activities. And because you did not give me that, I now have to go 3 weeks without a shower. Because I'm here today. I'm supposed to be showering today. And so when these scheduling of court hearings are made, I need, well, minimally, I would like 6 weeks advance.
All right.
Because I have to make arrangements.
All right, and I understand that, Mr. Shores, and the court will be doing this. The court's going to take your motions under advisement. The court will issue a written decision. In that written decision, if the motions are denied, and therefore there is still an issue as it relates to the parenting time and the child support contempt, I will set that on for a hearing on those issues. Because I will be ruling on all of the motions related to the underlying judgment by Judge Cahill, as well as your request for a jury trial, then those issues will all be determined, and if we're going forward, we're going forward on the motion for contempt and the motion for parenting time assistance. And so, Ms. Karst, if we go forward, then you need to be prepared to go forward on your motions.
Yes, ma'am. Also, for the contempt,
Yes.
there were actually 9 items, so is it just that one item that isn't?
Anything related to...
Objection.
Mr. Shores, I am talking. You can have an opportunity to respond after I have finished speaking. Ms. Karst, as it relates to, I'll address your motions as well in my order. And so if there are parts of your contempt motion that I do not believe that there is a valid basis under law for me to go forward on contempt, I will address specifically what those are. And if there's a valid basis to go forward on other issues, I will also address that.
Okay.
All right? All right, Mr. Shores.
Objection. Demand the proof that that was a valid court order. I cannot be in contempt of a non-valid court order.
And I understand that, Mr. Shores, and that's one of the issues that the court will be making a determination on and issuing a written decision. So you're going to get a written decision on that. And if the court finds that it wasn't a valid order for any reason, then we're not going forward with another hearing.
Will also be known that people will be, that's why I asked for the writ of subrogation, so that there's accountability financially for the trespass of my rights,
All right, and I understand what your motions are, Mr. Shores.
including Clay County.
And I understand that this is not an action against Clay County, this is an action involving you and Ms. Karst. All right, anything else from either party?
Just, I guess that everything, like, it comes off of Judge Cahill's order, which was part of our divorce decree trial. So he is a judge. I don't know where his argument that the judgment is void comes from. And again, it was upheld by the Minnesota Court of Appeals when he brought it to appeals. So.
And I understand your position on the matter. I understand, and that's why I made a record of the fact that 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 order was out there and that it was appealed, but I will make a final ruling. I just want to do a written order as it relates to all of the issues so that they're all addressed.
Objections, appeals don't supersede the Constitution of the United States.
And I understand what your position is, Mr. Shores. So, my final order will indicate what issues, if any, are left for the court to decide. Those issues will need to be addressed at a future hearing. Ms. Karst, if we are going forward with the child support issue, I would note that I did see there was an affidavit of arrears that was filed by, I believe, by county child support office.
Oh, okay.
That was a long time ago.
Objection, that even the,
One person at a time.
Mr. Shores. Mr. Shores.
the child support orders are all voided also.
There is no separate child support order. What I indicated is there was an affidavit filed from the child support office as it regards to what you have paid and what you haven't.
Okay, well, that's where one of my motions is because the child support is violating my constitutional rights, because show me where I have made any contract with them, giving them the right to take away my benefits. I have no income.
And Mr. Shores, the issue for the court is not whether or not Clay County has the right to basically take your money through income withholding or anything like that. The issue
Income withhold, sorry.
The issue for the court to determine, if the court determines that the initial dissolution decree by Judge Cahill is valid, the court makes that determination, then the issue for the court to determine as it relates to contempt is whether or not you've paid and whether or not you've had the ability to pay. Those are the sole issues for the court to determine in a child support contempt action, is what your obligation was, what you've paid, and whether or not you had the ability to pay. And so those will be the issues for the court to determine if we get to that next hearing. Anything else, Mr. Shores? Oh, what I had indicated, as I was trying to indicate, is there was an affidavit filed, but it's probably not updated. So, Ms. Karst, you're going to need to come forward to show me what has been paid and what hasn't been paid. Mr. Shores, it will be your obligation, if we go forward on a child support contempt action, to show why you did not have the ability to pay. So that will be the issue for the court.
I'm declaring with the American Disability Act that right now that I'm not getting due process of law. So I'm stating that all motions at this time be void because I can't even get access to my device.
All right, and what do you need access to that we can assist you in?
I have a list
Yes.
of all of my motions. I have a list of my terms that they use in court, and I have a list of my citations of other court cases to show that this right now is not a proper court.
And I'm assuming, Mr. Shores, that that was all in the filings that you filed in this matter from October to today's date.
Yes.
All right, and so the court has those motions, the court has reviewed those motions, and the court will review those motions again prior to issuing a decision.
Okay, well, if I may ask the court, if we can get this over and done with, because my rights keep getting trespassed on, and my children need to be taken care of.
Yep, and it's the court's intention to issue a decision as quickly as I can. So, obviously I have to address 30-some motions, but I will be issuing a written decision as quickly as I can. So, unless there's anything further from either of the parties, this matter will be concluded for today. I will, as I indicated, issue a written order on all of the issues and setting a further hearing if needed on any remaining issues.
Your Honor?
Yes.
Could I at least ask you to ask Mrs. Karst, why is it that she cannot just have a phone conversation so we can rectify any situation to get it over and done with, because it is an absolute hassle for doing text messages or emails where a phone conversation would be over and done with.
All right, and I can't order Ms. Karst to do anything. Obviously, if there's a way to resolve this, I'm gonna tell both parties that that's gonna be in both of your interests to resolve this outside of court action. And so if there's a way to do that, the parties should attempt to try and resolve all of these issues outside of court, because the parties you're the parents to these children and need to go forward.
Absolutely. That is the primary thing, is the children.
Can
So,
I respond to, I don't speak with Mr. Shores on the phone because of his behavior toward me, and he's been explaining this for many years and asked to, respectfully only communicate with me via text or email, because I don't want any contact with him. I don't deserve to be abused like he does.
Hearsay,
all right, and so
I
the court.
don't speak
yeah.
over the phone.
hearsay.
So the court's not going to get involved in the two of you communicating or what you're going to communicate. And so I've just indicated that if the parties can resolve this matter, you can resolve this matter, however you do it. And so that's all the court's gonna say on that. That's up to you as to decide how you're gonna proceed individually with the two of you. So. All right, I think we've covered everything that we can cover for today's hearing. As I indicated, I will be taking all of this under advisement, and I will be issuing a written decision. And so that will complete the hearing for today.
And, excuse me, ma'am,
Yes.
may I please apologize for my frustration? And please do not take it personal. It's just extremely frustrating with the stress and everything that this is putting me through.
And Mr. Shores, I didn't take offense at all. I understand, and I understand you were having some difficulties today. That's why I wanted to give you some additional time, and hope that you could proceed that way. And so I take no offense by your conduct today.
Well, as I've been trying to share with the disability coordinator at Rennell Fennel, I finally have gotten a new computer,
Good.
but there's issues with my Dragon speech voice backup. It got corrupted in trying to bring it to the new computer, so my new computer has to be trained from the beginning.
All right.
And-
And so, just to let you know, Mr. Shores, obviously you're gonna be getting a court order in the mail, or not in the mail, it will be coming through email as per the ADA order. But you will be getting that, and so if you have any difficulty with regard to, reading that, I'm glad that you got a new computer and that, that's,
Oh, also, and can I have it stated for the court that we use the KRS, court Gmail, and not, unfortunately, and if Ms. Karst, if you could please not send every little thing and put them in more groups, because it bogs down 702 communications.
all right.
My emails got bogged down and I missed some emails from Ms.
All
Karst.
right, so can you tell the court again, what is the email address we need to use?
It is the KRS Courts 2018 at gmail.com.
All right.
It-
I just want to, KRS Courts, like.
Court, yeah.
Court 2018 at gmail.com.
Yes, ma'am.
All right,
Is it court with the S or without an S?
Court.
It's a court.
all right. No
Singular.
S. All right. All right, that is the email that we will use in order to send the order from this hearing.
Your Honor, can I ask that he be ordered to bring his financial statement this time? Judge Cahill did order him to do that last time, and then everything got changed. So.
All right. And I understand that if we do go forward on the.
Violation of Fourth
Right.
Amendment.
Mr. Short, if we go forward on the child support contempt matter, I will simply note that under existing case law, if there is a valid court order out there, and I haven't ruled on that, but if there is a valid court order ordering child support, that is a prima facie evidence of an obligation and that Mr. Shores has the ability to pay. The obligation then is on Mr. Shores to show that he does not have the ability to pay. And so he will need to provide information to the court to show his inability to pay. And so I will leave that up to Mr. Shores if we get to that issue.
And ma'am,
Yes.
if you could find any proper serving or notification that I was giving during that entire court proceeding? That you are questioning my due process of law?
I guess I don't understand what your question was.
As it has been determined with this court of how to properly follow the ADA,
Yes.
it is obvious that that was not afforded to me prior. So I question the ability to make such a judgment of whether or not the orders are void or not.
Oh, you're talking about anything that happened prior to the court's ADA order? Is that your position?
Can you restate that?
I'm trying to understand what your argument is.
Well, my argument is that there's a challenge with coming up with a ruling of whether or not the original Cahill orders are void or not,
Yes.
where the burden of proof is to the court to show that I was properly given any kind of notification of proceedings.
All right, and I will just note that at least from my review of the record, that was a court trial that you, at least to some degree on some of the hearings, participated.
The first day, ma'am.
Yep, and that I will also note that then you appealed that decision with the assistance of counsel. And so, I understand what your position is, but.
Right, and may I also add that the counsel that was assisting me was disbarred because of his addiction to Adderall.
And
And
I understand that Mr. Mattson is no longer a practicing attorney, but I don't have any say in who was your attorney during the course of that appeal. So, as I indicated, I'll take the matters under advisement. I will issue a decision. We have your email, Mr. Shore, so we know where to send the order. Ms. Karst, we will send you the order in our normal course. And if there is a further hearing, then we will set that on for further hearing.
Your Honor, should I bring exhibits to that hearing? Okay.
If we have another hearing, you need to be prepared to go forward with all of the issues as it relates to contempt and parenting time assistance. All right? All right, that will be the end of today's hearing. Thank you both.
thank you.